picture of them. So it can be very difficult. So you've got to get the balance right, which leads me conveniently into the very last part of what I want to say. Because when we get rid of this, and that goes, and when we get rid of the gown, that goes. Okay, I'll leave these on for the time being, but I go back to my normal clothing, sweating as I am because it's hot wearing that stuff. I'm a mediator. Now, what is a mediator? Well, a mediator, and it's all part of what we call, you've probably heard the term ADR, Alternative Dispute Resolution. Well, actually, the word alternative is meaningless because it is dispute resolution. Alternative dispute resolution is basically anything other than court, although court is a dispute resolution, only a judge decides. When I do my work as a mediator, I think I'll finish with that now, Robert, if that's okay.
Oh, sure.
When I do my work as a mediator, it's a totally different type of discipline. I do have to have quite a substantial legal knowledge of all this stuff. I have to know what sort of trial might be being involved, because there are three types of trial. There's a small claim trial, a fast-track trial, or a multi-track trial. That's how most cases start. And it's all covered in here. The family court has the similar, we just use different names, but it's the same sort of thing. The small claims are up to £10,000. The fast-track claims are 5 to 25,000, and multi-track is any amount of money, but it's normally a complex claim. Now you can imagine that a lot of the work I do could be small claim. Small claims do not attract any costs. The big difference, which I haven't mentioned, which is one point I should have done perhaps a bit earlier, is in the States you have a different view about costs, legal costs. In other words, each side bears its own costs. Doesn't happen in this country, which is why this book is so big. And that document there is the costs document, because we can claim our costs. If we win, we can claim our costs from the other side, and costs in many cases are way above the amount of money in dispute, because much of the dispute is quite often about reputation and pride. In fact, a large number of these cases are. That's why mediation comes in, because we have a different system. And it's a system, because I have now retrained to be a mediator, and I can mediate internationally anywhere in the world with qualifications I have. If the parties agree, they have a contract with me as the mediator. It's an agreement to mediate. It's a detailed, long contract. The fees are paid in advance. The International Arbitration Centre is the main centre in London for the world. Singapore is our competition. But most people come to this country for arbitration at any level. The problem we have is that from April next year, the government have made a decision. It may be changed if there's a different government, I don't know. At the moment, from April next year, all these claims in the fast and multi-track areas will be automatically forced to a mediator like me first. Now, can you see what the changes are? These are very big changes. In other words, because we have a bit of a log jam with the number of cases and the amount of time it takes to get cases to court, and the fact that the courts have been closed, and we have fewer courts and many fewer judges, we have a big problem with recruit judges. As a result, next year, the judge will look at the papers that have come in for a claim. That's assuming a claim has already been made, and he will then order this case must be heard by a mediator. So the parties are forced to mediation. They come to me, and I use different skills to try to find out what it is they want. So the way I do it is we have a particular structure, a process which is totally different. It's very informal, first name terms. My job is not to give legal advice, it's not to try and cross-examine people or do anything. It's to ask them, what do you want to achieve today? What have you come here to achieve today? Have you thought about what the other side want? Have you thought about what they want? Have you thought of coming together? And then that's in a general open session, and we have private closed sessions where I'm much tougher because everything is confidential, it's without prejudice, so can't be heard in court, it's binding. And what we do out of that is we will get an agreement, because we threaten them basically. We say, do you know what will happen if you go to court? It will cost you a fortune. You probably will never recover the motion from someone, because it can be very, very difficult, depending on what it is. Many of the disputes, the parties have never spoken to each other. Would you believe it? Never spoken to each other really at all. Proceedings are issued. They've never actually sat down and said, look, we've got a dispute. Can't we do something about this? Can't we have a round table discussion? Never happens in many, many cases. So you can see why the concept of mediation is seen as a very useful method of actually changing the system, yes.
Can't mediation not be appealed, right? So or can it?
No, it can't, because the agreement to mediate, this is where the law will come in. The mediation, as I say, you have to be an accredited mediator, I am. There is an agreement to mediate, which is an 11-page contract, which the parties sign. They have to pay my fees up front. They agree that everything that's discussed in mediation stays in the mediation. It's confidential without prejudice, so you can discuss anything. Now, obviously, there are some problems I could have, and the one big one is what happens if a criminal offence is uncovered, or money laundering is uncovered, something. In those cases, there are certain things I have to do. Let's assume that doesn't happen. So if at the end of the to and fro, we have open sessions and closed sessions with the individual parties, offers and counter-offers to try to settle. Let's assume that they have settled, and we have a memorandum of accord, which says something like this: I agree to pay £15,000 to X by a certain date by direct transfer. No liabilities, paragraph 2, no liability is attached to either party. No party accepts any form of liability. 3, all these matters remain confidential and not to be divulged to any other party. And then both parties sign it, and I countersign it, because I countersign the mediation agreement. Once you've done that, it's binding, and it's binding on the courts. So if the party suddenly says, no, I don't like that, I don't agree with that, I understand that, they go to court. The court will say, no, you've already sorted this out, it's an abusive process, on your bike. Now, family law is slightly different, because what you've got, I'm talking about civil and commercial mediations. These are not, can be multi-million-pound mediations. Obviously, they're global. You don't necessarily have to have a grasp of law. Obviously, it's helpful if you do. But what you're trying to do is you're trying to find out what one side is saying, what the other side is saying, bring them together and see if there's common ground. Sometimes there won't be. Family law is different. You have a mediation service, you have a government organisation covering it. The rules are slightly different there because I'm going to talk about this area. It's an uncomfortable area for some, but for instance, the vast bulk of the cases I do involve domestic violence. Therefore, when it's a domestic violence issue, there are special rules applied to mediation. The mediation can go ahead, but it's a different type of mediation, and you have to be qualified as a family law mediator, which means you have to get additional sets of certificates. That's the one area. If I'm doing workplace mediation, which is employment law, industrial law, labour law, whatever you call it, that's the workplace disputes between employer and employee. That's a different specialism. Education, special needs, university arguments over exam results, whatever it might be, that's a different area as well, and so forth. They're all specialisms covering the whole area of mediation. But with family law in particular, that is different because you can understand that the allegations that are made in a family dispute are going to be very different from the ones that you have in terms of, say, a defamation action or contract. Obviously, in many cases, it's about reputation. And quite often, what the parties want more than anything else, they want money. They want an apology. If it's a clinical negligence case, which is what I did recently, where the claimant's toes were chopped off, but it was the wrong foot. In another case, the wrong leg was chopped off because the surgeon was completely incompetent and then dropped dead. So you couldn't get at the surgeon. You can get at the health service, National Health Service, which is what we have here. Again, these are special areas, specialist areas, because the government departments have mediation organisations, with the exception of two: Ministry of Defence, who will not mediate, and the Ministry of Justice. They won't mediate either. At the moment, we'll change that. But you can see that with the mediation arbitration concepts, because there are three types of if you like, mediation. There's mediation itself, there's arbitration, governed by the Chartered Institute of Arbitrators, and there's conciliation, which is ACAS. Conciliation is very similar to mediation. But what I do as a barrister in court is I already do the mediation in court, because in the family jurisdiction, and to a lesser extent in the civil jurisdiction, I have to attend court an hour before the proceedings start to talk to the other side, to see if we've got some common ground, because I'm expected to list those issues which the judge has to determine, which are the issues between the parties, to save time. Because how much do you think it costs to go to court? To go to the Crown Court is £8,000 a day. To go to a county court is about £4,500. Magistrates about the same. The High Court probably about 10,000. The Court of Appeal about 25,000, and you're starting at about 100k in the Supreme Court. That gives you an idea of the costs. All of the things that are covered here, obviously there are additional rules for the Supreme Court and so forth, but you get some idea that before you know where you are, you will read in the paper the costs awarded of £500,000. We are notoriously mean in this country when it comes to the award of damages, unlike America, where you're very generous. You give very substantial sums of money. You know, classic examples of people suing for a $20 million claim. And then you have class actions, which we don't have. Class actions are, I think, quite a good idea. Only we don't do it quite like that. Although, the case of Mrs. Carlo, the case of Miss Donahue and Stevenson Limited, the glass manufacturers, those were class actions, believe it or not, because they were just one of a number of cases all linked together, and that was the name that came to the top. But there were about 4 cases involving the same issue of law. So that is effectively a class action. But in the States, you have class actions in a different way. Obviously, class actions can work. For instance, if there's a huge, big environmental problem, a lot of people affected, you can then see that a class action would be very helpful. But in this country, the way we do it is one person will sue, and then everybody will basically, because it's precedent, everything will basically fall in line, and we will then settle. Because a very large number of the cases I do settle. Because if they know what they're going to get, and they've already seen me in court in interlocutory proceedings, that's proceedings before the main hearing, and they see what I'm going to be like, they don't want to be cross-examined by me. And they certainly don't possibly want to be cross-examined by the other side. Although I say one thing very reasonable. I may ask you a few questions, but the old sweetheart on the bench there, the judge, they're going to ask the nastiest questions of all. Because they can ask it whatever they want. I'm restricted, they're not. And remember that if I decide, for instance, in family law cases, where I'm the only lawyer in the room, apart from the judge, because most of the parties are unrepresented, which is what is a big problem for us.
So just to clarify, if you're only lawyer in the room,
Yeah.
what do you're not representing either party, because they don't have lawyers. What's your
No,
role?
I'm representing one of the parties, but I'm the only lawyer there because the other party is unrepresented.
Oh, they just proceed pro se.
That's right. Oh yeah, because I mean at the moment, because this legal aid doesn't really exist anymore for many cases. That's the state funding of cases. We have a position now where about a third, if not a half, of cases now, the parties are unrepresented. So that quadruples the amount of time the judge has to give to the parties, because you'll find many cases where, even in the High Court, you'll see this now, where the parties are not represented. So you go into court, if you see a person dressed like I'm dressed, that's obviously barrister. The likelihood is everybody else is representing themselves. So that means the onus is on me to make sure that everything is done properly, and the judge has to make sure. But in addition, in the family division, special rules apply. Because you can imagine that if I am cross-examining a vulnerable lady about domestic violence, sexual abuse of children, and I'm not going to go any further, but these are very detailed. You've got doctors' reports, you've got a lot of information, police reports and so on. It's very, very difficult. And it can look as though I'm going to be oppressive. So I have an out clause, Family Procedure Rule 11J, which says the judge can, if he or she so decides, ask the questions and act as an inquisitor to find out what's happened. So it's shifting from the accusatorial system of adversaries, you know, me as a barrister for dad, and another person's barrister for mum, or whatever, it might be the other way around. You've then got a position where the judge takes over. Now, as I've said to you, some of the judges I've been in front of can be pretty tough. You know, you don't like them, they do the wrong thing, you go, well, that judge, oh God, that judge, you know, I've had enough of him, that sort of thing. They try their best, but the fact is that when they take over, they get to ask very, very tough questions. And the parties won't like it. So, the pressure is on them. Money, don't go there, settle. If you don't like that, you're going to be cross-examined, you don't want that, settle. And that's how we do it. Yeah?
You said that you have certain restrictions that the judge doesn't have. Like, what would be an example?
Well, in the courtroom, the actual court scenario itself, the development of evidence, this is the court case, when I am representing a claimant, and I can ask the claimant some questions, they're called supplementary questions, so that the evidence the claimant is putting forward is the witness statement and the exhibits. But something may have happened which means I have to ask additional questions. I cannot ask what are called leading questions. It's the same in the criminal system. And now, do you know what leading questions are? Never heard of them? You nodded your head. I don't want to put you on the spot, but tell me what you think now.
It's almost like asking a question so that they almost admit some sort of form of guilt, or
it's where the answer is inherent in the question.
yeah.
So, what is your name? So let me start off. I mean, this is a classic I had. This was with an American professor who should have known better up in Nottingham. He was very proud of being counsel for criminal matters in the States. Well, I can't remember what it was. And we had a row right at the beginning because you don't, when you put your man in the witness box, I'd say man, it could be a woman, in the witness box, you don't say, your name is Fred Boggs, Fred Smith, and you live at 3 Railway Cuttings Cheap, and you are a bricklayer. You don't do any of that because all of those are leading questions, unless you get permission from the other side. Now, the reality is that you will get permission from your opponent to ask leading questions in certain cases because it moves the thing along quickly. However, I pointed this out to the American guy who didn't like my attitude. I didn't like his attitude because I actually do this in court. I had a case, in fact more than one case, where my client was an inveterate liar. He couldn't tell the truth about anything, including what his name was and where he lived. So instead of saying to him, you are Fred Smith and you live at 3 Cuttings Cheap, I said, what is your name? Where do you live? What is your occupation? So he had to think, and he said, I wonder what my name is today. What address am I going to give today? Because it was a fraud matter. He was actually a fraudster. And he was trying to think about which it is. Do you see what I mean? Very quickly. So the common law and our rules, both in civil and criminal procedures, come from the common law. Because remember what I said about the criminal system, which is the basis of the problem. Everything is based initially on religion. So that when you gave evidence on oath, and you told a lie, you perjured yourself, the concept in the 19th century was if you did that, you would be damned and you would go to hell. So therefore, the courts in the Victorian era said, well, there's no point in doing that, so the defendant is not allowed to give evidence on his own behalf. So for many decades, during Charles Dickens' era, the defendant never gave any evidence. Because if he did, he would lie. Then he'd be damned. So it's best to hang him now and get him out of the way. Now, I know I'm cynical. I don't believe in capital punishment at all. I think you guys are going completely wrong in the States, and I've told your Supreme Court people that about that and gun control. Not that it's any of my business, but you don't tell me about the IRA, and I won't tell you about about gun control. Because the point is that there has to be a balance. But you will see, from what I'm saying, that the concepts were very, very... The common law was incredibly rigid and ruthless. If you didn't do something, you were dead. You were just executed. If you've seen Garrow's Law, which was on BBC television, this is about the beginnings of the modern law of advocacy, modern rules of advocacy by Sir William Garrow. This is in the 18th century, where they would execute anybody. I mean, the judge would listen for a few minutes. Sometimes they'd ask the defendant if he had anything to say, but he'd be found guilty and then taken out and hanged. Now, the point is, they were never given an opportunity to say anything. They had to do it through their counsel, their barristers. Now, we changed that in the end of the 19th century so that prisoners at the bar, the defendants, were allowed to give evidence in very special circumstances. Criminal Evidence Act 1898. That act was in power and for nearly 100 years because it was obviously changed by statute. But the basis of it was trying to modernise. This lot, the civil procedure laws, came in this century after a tremendous amount of change. We are going through exactly the same change now because the online courts are coming in. The online courts, which I said will be the future, will be where, as we do now, we have evidence given by video link. And there are problems, because we don't know who's in the room with in the place where the person's giving the video link evidence from. We don't know what prompting is going on. When I've asked for video link evidence to be included, the judge has refused, saying I don't know who's in the room, don't know who's prompting him to give evidence, so I'm sorry, he's got to come to court. So you see where we are. Now, I've run over my slot a bit. Any other questions you've got for me? No? Yeah, yes.
Just a quick one. So the parties that go unrepresented, how often do they come out successful?
I can't answer that, except to say that what is success? Because you mean win or lose?
Yeah.
See, what I do, it's not about winning or losing. Win or lose means acquitted or convicted. There's no mediation, criminal, and litigants in person. The majority of people in the Crown Court will be convicted, although there is quite a sizable percentage who will get off who we think will be guilty. But we don't know, so they're innocent. In the civil matters, winning or losing is slightly different because you're going for court orders. So winning could be winning damages or winning an injunction. The likelihood is about 70%. But a lot of it is not about that. It's about trying to get some sort of agreement. So if we could get to a position where when we negotiate prior to the hearing and they settle, and 50% of cases at least are settled, 60%, quite often it could be more depending on what it's about. That means if you take that as a win-win, that's the win. The fact the number of people who lose is quite high because they will lose everything, they'll be bankrupted. There's a case involving a cyclist who basically caused an accident and as a result has got £100,000 damages award against him, which will bankrupt him for inappropriate cycling. And he didn't have any cycling insurance cover. Now, of course, if you're driving a car, you have to have cover. But is it a win or a lose? Because if you're actually in a road traffic accident case and the judge decides you caused the accident, well, you've obviously lost the case. But you're not really paying because the insurance company are paying. You see what I mean? But I mean, in general, I hope that probably answers your question, but there isn't one simple yes or no, because you're not looking at it from that point of view. Okay.
Well, if there's a last question, I'm sure it must be a big transformation over the past 20 or 30 years. What are your thoughts on diversity in the court system, barristers and solicitors? I assume at one point it was purely a man's game.
Yep.
Maybe a white man's game. Has that changed?
It has.
Has it changed fast enough?
Yes, and in fact, last couple of weeks, we've just celebrated 100 years since the first female was allowed to be a barrister. Disgraceful. I'm part of the University of London, where we've celebrated women being allowed to be granted a degree. I know some universities have done, obviously you go back a bit. If you look at it in terms of diversity, we have come a long way very quickly. We have got, I've got to be careful what I say here, because diversity, it's an open end. You can cover everything. You have to draw the line somewhere. Diversity, in my view, means that there has to be a level playing field for men and women in the acquisition of qualifications and professional activities. And therefore, the workplace today should be equal between men and women. When I first started 50 years ago, when I first started working 50 years ago now, it was a very different world. Women just weren't in the workplace. They were at home with the children. It's not like that anymore. The workplace is different. A lot of it's done at home. When it comes to minorities, we have a major problem with recruiting minorities to the bench. And I'm going to be blunt with you. It was raised the other day in mediation. If you are a black defendant, you are not going to want to be defended by a black person or woman. You normally want someone like me. And I don't like it, but they normally will, defendants will normally want a white Anglo-Saxon Protestant, plummy voiced posh person like me. Possibly, or not possibly, to represent them. Don't like it, but that's the way it is, because that's about human nature. And we've got to get away from that. The view is that if they have representation by, let's say, Jamaican by Jamaican, they may feel that the jury is going to be looking at them in a different way. I don't know that that necessarily is right at all. I think that's pretty racist, actually. But I have to be blunt and say that is the sort of problem we have. You go into the cells at Brixton, and you will see that an awful lot of black people are represented by white people. Now, it can be white women as well as men, although it's still likely to be a man rather than a woman. Whereas in family law, a large number of my opponents are women, vast bulk of them, they think it's women's work, family law. It isn't. It's everybody's work. But we've got a large number of minority BMEs grouping. We would like to see many, many more on the bench. We'd like to see many more being called to the bar. We are. We've got more women than men now reading for the bar. We've got more women solicitors than men solicitors. So the answer is that we've got the balance. We haven't in the House of Commons. I mean, Blair brought in 100 Blair babes, as they call them, and many of the women did not like what they saw. And we've got a report this morning about John Burko, again, the Speaker of the House of Commons, about this nasty problem of bullying and sexual harassment in the Palace of Westminster because of the diversity problems. Now, it's not going to go away, but what I am saying is we are a land of opportunity like America is. We do believe in taking people on the basis of merit and ability. Prejudice comes into it. It shouldn't, but it does. If we can stamp it out, we will. As a teacher, if I found the kids bullying each other, I'd stamp on it immediately. Now, in the army, it was even worse, because if I found in my platoon that I was getting bullying, that had to stop immediately, because you are only as good as your unit in war, because just one loose chink and you're dead. It's as simple as that. I know that sounds melodramatic, but that's the way it is. So the answer to that is that we are moving ahead quickly, but I'll tell you one thing that I am unhappy with. How far do you go? Do you go as far as very severely handicapped people and trans people? Because that is where it's going at the moment. That is where the